Welcome to online study of the Mohammedan law in India. You know that the marriage according to Mohammedan law is a civil contract. So getting divorce under Mohammedan law is very easy. The absolute power of giving talaq is given to the Mohammedan husband. Even a Mohammedan husband can divorce his wife at his own will, through at caprice or pleasure. For that, this power is there. This is called talaq. Talaq and divorce are two different things. Talaq, though it is construed, or the meaning is that is understood in the same sense, that is divorce. But talaq is only a power which is given to the Mohammedan husband to divorce his wife. But at the instance of the wife, sometimes there is also divorce under the Muslim woman, this act, that is divorce under the Muslim woman divorce act. Thereby, the wife can obtain divorce in certain, both husband and wife can obtain divorce. So far as talaq is concerned, when talaq is given by the husband, no decree of the court is required. First is talaq. So divorce, you know that by giving divorce, when there is a divorce, that dissolves the marriage. The marriage ties between the husband and wife comes to an end. So talaq is usually, that is rendered as repudiation in law. Usually repudiation, cancellation of marriage. It is absolute power which the husband possesses. Talaq power is that absolute power the husband possesses to give divorce to his wife whenever he requires. So that's why dowry is there. Once the talaq is given, the dowry is to pay. The divorce operates from the time of the pronouncement of talaq. Once the talaq is pronounced, so on that pronouncement, divorce operates. That value pronounced in the presence of it is not necessary that talaq is always to be present, that is to be pronounced in the presence of the wife. It is essential that such pronounced must be communicated to the wife. Effective is made known to her. It is not necessary that Mohammedan husband will pronounce talaq in presence of the wife. If it is communicated from the date of communication, that marriage is dissolved. Communication is an essential element, a requirement for talaq. Otherwise, it will be deprived of our right past talaq. So, the date or the day on which talaq is communicated to the wife, then from that day the marriage comes to an end. The words used must indicate a clear and unambiguous intention to dissolve the marriage. Again, the pronounce of talaq, the talaq word, must be clear whether it's Arabic form or in any other form. But the words must indicate clearly and unambiguously to dissolve the marriage. Suppose you may say, I divorce you, I divorce X forever, or render her haram for me. This, in which case no proof or this intention is necessary. But the words are sometimes ambiguous, sometimes words are ambiguous. The intention must be proved. For instance, in ambiguous is, I have given up all relation with you. So by uttering those words, by saying those words, no clear intention of talaq or divorce is given. So in such case, it may not be a valid divorce. So in Shia law, strict adherence to certain forms is essential. According to Shia law, divorce, the talaq must be pronounced strictly according to certain formal words. The pronouncement talaq in the Arabic tongue is required. According to Shia law, Talak must be produced in Arabic language, must be uttered orally in the presence or hearing of two male witnesses. That is not required under the Sunni law. So here, who are Muslims approve that is forbidden, that is 10 persons, 10 witnesses. In their presence, this talak will be given by the husband according to the Shia law. So if witnesses are not there, then that will not a valid talak. Only the husband is physically incapable of pronouncing orally, then such talak may be made in writing. In certain cases, that husband is unable to utter the words. In such case, such talak may be made in writing. So the pronouncement talak may be either revocable or irrevocable. What is revocable? That can be withdrawn. The revocable form of talak are considered as the approved talak, but the irrevocable form are treated as the disapproved form. That is triple talak, disapproved form. The form of talak may be classified in following: talak Hassan, Ahsan, talak Hassan, talak bidat. So the forms of talak, you should know when you write answer something what is talak. Talak is, that is, this form of talak may be classified. Talak is classified in three types of talak. One is talak Ahsan, talak Hassan, talak bidat. Then so-called triple talak, that is talak with bidat is triple talak. Now it is not legal. That is after passing of this triple talak act, that is not, that is one, but previously it was irrevocable, now it is made illegal. So only talak Hassan and talak Hassan. Talak Hassan means the pronounce made in talak Hassan is revocable during iddat, where the parties have been away from each other for a long time, where the wife is old and beyond the age of menstruation. The condition of tur is unnecessary. Tur means what? Tur means, this is a, you should understand certain thought. Tur is done. Tur is a period, that is, during that period of sexual purity, after menstruation till menstruation, that is sexual purity. Ahsan form consists of one single pronouncement. In talak Ahsan, there is one single pronouncement talak in the period of tur. So during period of tur, only there will be a single pronouncement and followed by abstinence from sexual relationship. In single pronouncement during tur period, after menstruation, the period that is called period, that is purity period. That is in Mohammedan law, that is called tur, as well as that is also like iddat. In such case, if under single pronouncement, abstinence from sexual relationship during that period of sexual purity. During tur period, what is tur? Sexual purity. That is during that sexual purity period, that is abstention from sexual relationship, then that is called talak Ahsan. Not necessity of triple talak. Mentioned. Takes place the divorce is, so if during that period, even if a Saudi husband has pronounced talak, but in spite of that, he keeps sexual relation, then the talak is of no use. First, for the single pronouncement, abstinence from sexual relationship. Then where the parties have been away from each other for a long time, or where the wife is old and beyond the age of menstruation, the condition of tur is unnecessary. The pronounce made in the Ahsan form is revocable talak. It is called revocable talak. Why? Because once talak is pronounced, suppose the husband, because of some anger, something, he pronounced the talak during tur period, and after pronouncing talak, keeps physical relationship with the wife, then that talak, that Ahsan talak is withdrawn. Such revocation may be even express words, even by express words or by conduct. Even single talak is pronounced, thereby the husband withdraws the words. After the expression, that is, resumption of conjugal intercourse is a clear case of revocation. after pronouncement of talak Hasan, and again this physical relationship exists, thereby it proves. So that's why that is to be treated as the talak is revoked. After the expiration of iddat, the divorce becomes irrevocable. But during tur period, talak is pronounced, the entire tur period is over, then the divorce becomes, the talak becomes binding. The pronouncement of talak in the Hasan form is very best kind of talak. So that's why the best kind of talak is talak Hasan. Talak Hasan means pronouncing talak, and during the period of tur period, and abstinence of the abstinence from sexual relationship during the entire tur period till the further menstruation period, then that is a valid talak. But if during that period the Muslim husband can withdraw the talak either verbally or by his conduct, this is called talak hasan. You should understand what is talak hasan. Talak hasan means, talak hasan is also another approved form of divorce. It consists of three successive pronouncements during three consecutive periods of puberty. This is pronouncement of talak during three consecutive period of tur. Tur means what? Purity. Period of purity. So even one after one tur period, the other period there is relationship, then the talak is withdrawn. Pronouncement should have been made at a time when no intercourse has taken place during that particular period of purity. In the case of non-menstruating wife, the pronouncement should be made during a successive interval of 33 pronouncement. Talak Hasan, Talak Hasan, three pronouncement during three tur period. That is called Talak Hasan. Talak Bidai means triple talak. It is no longer a good law. It is no longer valid. The triple declaration in this form, three pronouncements are made in single tur. Either in one sentence, I divorce thee triple or thrice, or in three sentences, I talak, give you talak, I divorce you, I divorce you, I divorce you. That is triple talak. So now it is not approved. That is made not lawful now, and may be given in writing. Such a bill of divorcement comes into a operation. So you by now you are clear what is talak, talak hasan, talak hasan, talak hasan in once pronouncement during one tur period, no relationship, then that is the talak is binding. But if during that period the Muslim husband can withdraw that talak, talak Hasan, there will be three pronouncement on during three menstruation period. That is tur period. That is tur period. That is purity period. So here that can be also withdrawn. Now divorce when effective. In the Hasan form, the divorce effects on the expiration of the iddat. In the Hasan form, the divorce effect on the third pronouncement. In case of Hasan, Talak Hasan, only divorce becomes effective on the expiration period of the iddat period. That is, once talak is made, again the wife will also undergo iddat period. So here, that is, after that iddat period, that talak becomes binding. Similarly, talak Hasan. So here, divorce on the third pronouncement. In such case, no iddat is required. Third pronouncement. In talak of biddat, the divorce is immediately that is effective, but now it is not lawful. Now, what is legal effect? So this is first is talak. Then second form of talak, second type of talak is talaq-i-tafweez. Talaq-i-tafweez means this power of giving talak is delegated by the husband either to the wife or to a third person to pronounce talak, either the wife to herself or a third person to the wife, if a particular condition happens. This is called talaq-i-tafweez. The husband in Muhammadan law has the power to delegate this right of talaq, pronouncing talaq, to a third person or to his wife also. A stipulation that under certain specified condition, with a stipulation that if a particular condition happens, then the wife can pronounce talaq to herself and she will get a divorce. Suppose there is a condition that the husband will marry for the second wife, the wife can talaq herself, or a third party is delegated, he can give talaq. So that the condition must be a reasonable condition. Option is not absolute and unconditional. Secondly, that the conditions are reasonable and not opposed to public policy. The delegation of power of divorce may either be permanent or temporary. For a temporary for 3 years, 5 years, or a permanent. A temporary delegation of power is irrevocable, but a permanent delegation may be revoked. With this delegation of power, even that can be withdrawn. So, an antenuptial agreement by a Muslim husband and the wife that he would pay separate maintenance to the wife in case of disagreement, and that the wife should have the power to divorce herself in case of failure to pay maintenance for certain period. In such case, she can get divorced by pronouncing talaq to herself. That is valid. So this is called talaq-i-tafwiz. Talaq-i-tafwiz means what? Here in this case, the Muslim husband has delegated the power, that is of pronouncing talaq, giving talaq to the wife herself or any third person on happening of a particular condition. This is first, these are the talaq. Then the third is, illa. Then third type of this divorce. This is first talaq, this is talaq. Second is illa. What is illa? Illa means vow of not keeping sexual relationship. This is not common in India. Although it is mentioned in Sharia Act 1937, they are very rare in India. This illa form of divorce is very rare in India and of no practical importance. In illa form of divorce, in the illa form of divorce, what is? The husband swears in the name of God not to have intercourse with the wife and abstains for 4 months or more. So in such case, the husband swears in the name of God that I will not keep any sexual relationship with you for 4 months or more. The husband may in such case revoke the oath by resumption of marital life if during that 4 months simply has taken a vow, in the name of God, he has made a promise not to keep sexual relationship with the husband, with the wife for more months. If during that period, if he did not keep his promise, then that is revoked. So this is called, that is illa. Illa means vow of continence, vow of not keeping sexual relationship. This is available to husband. Husband takes a promise in the name of God that he will not keep any sexual relationship with the wife for 4 months or more. If the husband doesn't keep any sexual relationship with the wife for 4 months or more, then there is a divorce as per that illa. Then third ground is jihar. What is jihar? Jihar is a very peculiar form of divorce under Mohammedan law. If the husband compares his wife with any of his female relatives with whom he cannot marry, then the jihar, then a chance comes to the wife that the wife will ask the husband, you undergo penance. That is what type of penance? Either make free of a slave or pay 60 beggars, or feed 60 beggars for a certain period. So, if he doesn't do, husband doesn't make any penance, then the wife can file a suit for getting divorce. What is that? The husband who is a sane and adult, in case of jihar, the husband who is a sane and adult compares his wife to his mother. Suppose the husband says in jest, you are looking like my mother. So there, the jihar form of divorce, jihar, the wife with his mother or any other female within a prohibited degree, or with any other female, or compares the wife with his sister. So in such case, if he intends to revoke this declaration, so he has to pay money by expiation. Expiation means what? Prayashchita. That is, if he wants to revoke this, intend to revoke this declaration, comparison, he will make some expiation or fast for a certain period. The husband wife may ask him to fast for a certain period. After the oath has been taken, the wife has the right to go to the court and obtain divorce or restitution of conjugal on explanation, expiation. Expiation means what is that is practice. So this is jihar form of divorce. What the husband compares that the wife is looking like his mother or sister with whom he is prohibited to marry. In such case, the wife gets a right to get divorce. That wife will ask the husband, you undergo some expiation or that is you fast for certain days, pay free your slave or make some that is pay some money that is or to undergo a fast. If you do not undergo this expiation, then the wife may file a suit for obtaining divorce. Then the third is that is Mubarak and Khulla. Khulla, on the day I have stated you, Khulla means the wife offers the husband to give him talak, give her talak on payment, on receiving some property or by foregoing her dower. So in this case, law means laying down that by a husband is right and authority over his wife. So Khulla is a divorce with the consent and at the instance of the wife. Khulla is a divorce that is at the consent and the instance of the wife. That is, or the wife agrees to give some property or to forego or that is dower. In such case, this if the husband accepts, you will pronounce that is Khulla divorce. Mubarak, that is divorce by mutual consent. This is mutual consent divorce. It involves an element of mutual consent. That is Mubarak. Divorce by mutual consent is called this divorce by Mubarak. That is mutual agreement. So now legal effect of Khulla and this Mubarak, you know. Now, due to that is dissolution of judicial process. That is mutual imprecation. It is mentioned in Quran and is supported by the tradition of the Prophet that the procedure of lien that must be maybe described briefly as follows. That is, you see, apart from that, there may be divorce as per the Dissolution of Muslim Marriage Act 1939. In this act, there are, apart from this, 9 grounds are there for divorce. What are those 9 grounds? Section 2 of the Dissolution of Muslim Marriage Act 39 provides 9 grounds under which a Muslim wife can obtain a decree for a dissolution of marriage. Muslim wife, here the wife can obtain the talak power is there with the husband, but this power is given to the wife. That is as per section 2, this 2 of the Dissolution of Muslim Marriage Act 1939. What is that? Muslim wife can obtain a decree for the dissolution of the marriage on the following ground. First, absence of husband. If the whereabouts of the husband is not known for a period of 4 years, suppose the whereabouts of the husband is not known for 4 years, a woman married or a Muslim, they shall be entitled to obtain a decree for dissolution of her marriage. But decree passed on this ground will not take effect 6 months from the date of such decree. But under the Hindu Marriage Act, dissolution of marriage 7 years. So here, if the husband is absent and his whereabouts is not known, husband is not known for a period of 4 years, then the Muslim wife can pray the court for a divorce, and when a decree is passed, in that decree, that will not take effect for 6 months after passing of the decree, and the husband's relatives are to be implicated as parties in that case. So period 6 months, that is such decree, and if the husband appears, suppose a decree is passed, thereafter the husband appears either in person or through an authorized agent within that 6 months period and satisfy the court that he is prepared and to perform his conjugal duties, then the court must set aside that divorce decree. Then second is failure to maintain. So here maintenance is a right of a woman, the Muslim woman, from her husband. That even she has property, she has income, still she is entitled to get maintenance during her marriage with her marriage, during subsistence of marriage. So the subsection 2 provides, if the husband has neglected or has failed to provide for her maintenance for a period of 2 years, a married Muslim woman can obtain a decree for divorce. This is second ground. That if the Muslim husband has been neglected to provide maintenance to the wife for 2 years or more, then the Muslim woman can obtain divorce. Third is this is third is imprisonment of husband. Third is imprisonment. If the husband has been sentenced to imprisonment for a period of 7 years or upwards, the wife is entitled to obtain a decree of divorce. Third ground, suppose the husband is sentenced to imprisonment for 7 years and upwards, the wife is entitled to decree of the court dissolving her marriage. But no decree can be passed on this ground unless the sentence has been become final. So when a sentence has become final for 7 years and more, then the Muslim, these are the rights given to the wife. That is, under section 2 of the Dissolution of Muslim Marriage Act, the Muslim woman can file a petition for obtaining divorce. Third is imprisonment of the husband. Fourth is failure to perform marital obligation. If the husband has failed to perform without reasonable cause his marital obligation for a period of 3 years, the wife can get her marriage dissolved by means of a decree. Marital obligation, not keeping any relationship, everything. Impotency of husband. This is another condition. Fifth, if the husband was impotent at the time of marriage and continued to be so, the wife is entitled to judicial divorce for the dissolution of marriage. Before passing a decree on this ground, the court shall, on application by husband, make an order requiring the husband to satisfy the court within a period of 1 year from the date of such order that he has ceased to be an impotent. And if he does so, satisfy, the decree shall be passed on this ground. That is, will be cancelled. Then, sixth condition is insanity, leprosy, or venereal disease. What? If the husband has been insane for a period of 2 years, or suffering from leprosy, or virulent venereal disease, the wife may claim a judicial divorce. That is, for decree of divorce. Repudiation of marriage by wife, that is, option of puberty. If she having been given the marriage, suppose the Muslim woman had been given marriage during her minority by his guardian, and on her attaining 15 years, repudiated the marriage before attaining the age of 18 years, the marriage is not consummated. The marriage has not been consummated. Then before attaining age of 18 years, the Muslim woman can repudiate the marriage and ask the court for dissolve the marriage by a divorce. She is entitled to a decree of divorce. This is called repudiation of marriage by wife. That means if a Muslim woman has been given marriage by her father or other guardian before attaining 15 years, and after her attaining 15 years, that is option of puberty. It is called option of puberty. Then before 18 years, if the marriage has not been consummated, suppose the marriage has been consummated, this ground is not available. Marriage has not been consummated before her attaining 18 years, the Muslim woman can file a suit for divorce. The court have taken the view that the minor wife does not lose her right of repudiation if she does not know that she has the right, and therefore she can exert the right after she comes to know it. Then eighth ground is cruelty. Cruelty is common. Even under Hindu law, you find Hindu Marriage Act, cruelty is a ground for divorce. So here is under the Muslim Dissolution of Muslim Marriage Act 1939, the wife can obtain divorce on the ground of cruelty. What is that cruelty? Judicial divorce may also be claimed by a Muslim wife if the husband treats the wife well for it. What is cruelty that has been mentioned? Second, first, habitually assaults assault the wife, makes her life miserable by cruelty, bad conduct, even if such conduct does not amount to physical ill treatment, mental ill treatment, bad conduct. Second, association with women of ill repute or leads an infamous life. The Muslim husband, if he is associated with other women, ill repute women, leads an infamous life, then that will be treated as cruelty. On that ground, the Muslim woman can claim divorce. Attempt to force her to lead an immoral life that is keeping relationship with another, that will be also treated as cruelty. Disposes of her property or prevents her from exercising her legal rights over it. This will all be treated as cruelty. Suppose the husband disposes the Muslim wife from her property or prevents her from exercising her legal right over her own property, then that will be treated as cruelty. Abstracts or in observance of religious, obstructs in the performance of a religious profession or practices, that will also be treated as cruelty. If he has more wives than one, because you know a Mohammedan husband can marry up to 4 wives. If he does not treat a particular wife with equality, with equitably with other wife, then that will also be treated as cruelty. The ninth ground is grounds of dissolution recognized by Mohammedan law. The wife is entitled to decree for dissolution of marriage on any other ground which is recognized as valid for the dissolution of Muslim law. Those are, as I discussed you, jihar, khulla, mubarak, that is talafi tafis, imputation of unchastity, false charge of adultery against the wife, all those grounds. That is, what are those grounds? As I told you, illa, jihar, mubarak, khulla, on those grounds, this divorce can be the wife may abrogate divorce as per the provisions of section 2 of the Dissolution of Muslim Marriage Act. So this is revocable, irrevocable divorce. A pronouncement of talaq may be either revocable, that is, as I told you. So sometimes, if the wife they accept the other religion, what will be the consequence? That is that according to the general principle, Muhammad, a person who embraces Islam is immediately governed by Islam law. But a person who renounces Islam suffers greatly under civil law as well as criminal law. So, in order to understand the principle underlying the body of rules relating, suppose husband renounces Islam, what will be the consequence? Wife renounces Islam. Suppose your husband renounces Islam. A Muslim husband who converts to another religion, that is called an apostate. Islam is an apostate, and as such, his marriage with his Muslim wife is dissolved ipso facto. First thing, this is another condition. When the Muslim husband is converted to another religion, the marriage with his Muslim wife is dissolved, automatically dissolved. A Muslim married couple abandon Islam and adopts another faith. Their marriage is not dissolved but remains intact. Suppose married both the couple, they accept another religion. Thereby their marriage is not dissolved, that is still continued. Suppose wife renounces Islam. Suppose, as you know, husband renounces Islam, marriage comes to an end. If both of them renounces Islam, marriage doesn't come to an end. But suppose wife renounces Islam. The mere renunciation of Islam by a Muslim wife does not itself dissolve her marriage. This is the disparity. If the husband renounces the Islam, automatically the marriage comes to an end, marriage dissolved. But the wife renounces Muslim, thereby the marriage is not ipso facto dissolved. So it does not apply to women converted to Islam from other who re-embraces her former faith. Similarly, even if a woman who converted to Islam from other religion, who re-embraces her former faith, thereby this marriage is also not him. So Dissolution of Muslim Marriage Act gives a remedy. The statute provides that apostasy by itself does not dissolve the marriage unless it be that a woman re-embraces her former faith. If the woman, unless accepts his former faith of Islam, then that because of apostasy the marriage is not dissolved. Husband embracing Islam, that is, as I told you. So here, according to Islam law, conversion to Islam on the part of the man following a spiritual religion such as Judaism, Christianity does not dissolve his marriage with it. Suppose a Muslim husband, he accepts, he is converted to Christianity or Judaism, thereby his marriage with a woman belonging to his old creed, that doesn't dissolve. In that case, the Muslim husband could not lawfully retain a non-kitabia wife because they are kitabia, because they are following some their scripture religious in book. So here, a non-Muslim lawfully married in accordance with his own law cannot by mere conversion to Islam dissolve his own marriage. Similarly, a non-Muslim, when he converts to a Muslim religion, thereby his previous marriage is not thereby dissolved. Thus, if a Christian lawfully married to a Christian woman, declare himself to convert to Islam and may marry a Muslim woman, a Muslim fashion, the second marriage would be in the judgment of Supreme Court, this Sarla Muddal case. That will not be a valid dissolution ban unless if there had been a bona fide conversion both parties to the Islam faith. This is that is wife's conversion and husband's conversion. So now effect of dissolution. So once a marriage is dissolved, after the dissolution is effective, matrimonial intercourse between the parties becomes unlawful. Second is remarrying. A divorced couple cannot always remarry. Fresh marriage, when the marriage was consummated, the wife has to wait till the expiration of iddat in order to be able to marry. Where the marriage was not consummated, the parties can marry immediately. Dower, that is, if the marriage was consummated, the whole dower is immediately due. That apart, a principle that is a practice of halal. Halal practice is there. Suppose the divorce takes place, talaq takes place. Thereafter, the wife again wants to marry the previous husband. In such case, she cannot marry that previous husband. And then she will undergo a halal. Halal is a form that the wife, divorced wife, will marry another man, and this her marriage with that man will be consumed, and that man will give a divorce. Thereafter, she will undergo iddat. Then thereafter, she can marry her former husband. This is a practice of halal. You search what is the practice of halal in this internet, and you can know better. You will understand what is the practice of halal. That is still prevailing in Muslim law. So this is in nutshell. We discussed what is divorce, that is judicial divorce, Muslim section 2 of the Dissolution of Muslim Marriage Act 1930. You go through it, simply you got a bare idea about divorce under Muslim. Thank you.